5 seconds to go. Start. In ordinary parlance, if the period spent before wrong forum, if excluded, and application is filed within 3 months, then application is not barred by limitation. Certain disputes having arisen between first respondent and appellants, the first respondent filed an application under Section 11 of the Arbitration and Conciliation Act 1996, Act for short, and an arbitrator was appointed. The arbitrator made an award dated 6 February 2009. The appellants, being under an impression that the proceedings under Section 34 of the Act for setting aside the award was in the nature of an appeal against the award, filed an appeal under Section 34 of the Act before the Guwahati High Court on 6 May 2009, numbered as Arbitration Appeal number 10 of 2009. On receiving the notice in the execution levied in regard to the award dated 6 February 2009, the appellants realized that the proceedings under Section 34 of the Act was not by way of an appeal before the High Court, but by way of an original application before the District Court. However, as by then the courts were closed for the Puja holidays between 25th September 2009 and 19th October 2009, the appellants filed the application AC number 512 of 2009 under Section 34 of the Act before the District Court Kamrup, Guwahati, for setting aside the said award on 19th October 2009 when the courts reopened. Along with the said application, appellants filed an application under Section 5 of the Limitation Act 1963 instead of filing an application under Section 34(3) of the Act for condonation of the delay in filing the application under Section 34 of the Act. On 29th October 2009, they filed an application before the High Court for withdrawal of the appeal, and the High Court permitted them to withdraw the appeal on 30th October 2009 on the ground that it was not maintainable, with an observation that the question of condonation of delay will be considered by the District Court Kamrup, before which the application had to be filed. The appellants took back the application for condonation filed under a wrong provision of law, Section 5 of the Limitation Act, and filed an application under Section 34(3) of the Act on 3rd November 2009. At the hearing of the said application on 21st December 2009, as the court was of the view that application should have been filed under Section 34(3) of the Act, read with Section 14 of Limitation Act, the appellants filed yet another application on 8th January 2010 under Section 34(3) of the Act, read with Section 14 of the Limitation Act 1963, for excluding the time spent bona fide in prosecuting the proceedings before the High Court, and withdrew the earlier application for condonation of delay. The District Judge Kamrup, by order dated 26 February 2010, dismissed the application for condonation of delay. The appeal filed by the appellants against the said order refusing to condone the delay was rejected by the High Court by the impugned order dated 7th April 2010. The appellants have challenged the said order of the High Court in this appeal by special leave. Section 34(3) of the Act provides that an application for setting aside an award may not be made after 3 months from the date of receipt of the arbitral award. The proviso thereto enables the court, if satisfied that the applicant was prevented by sufficient cause, to entertain the application within a further period of 30 days, but not thereafter. This court in Messrs. Consolidated Engineering Enterprises versus the Principal Secretary, Irrigation Department 2008-7 SCC 169, 2006 AIR SCW 4182 held that neither Section 34(3) nor any other provision of the Act excludes the application of Section 14 of Limitation Act 1963, and the provisions of Section 14 of Limitation Act would apply to applications under Section 34 of the Act. This court held that even where there is jurisdiction for applying Section 14 of Limitation Act, the period of limitation will continue to be 3 months, subject to extension under the proviso to subsection 3 of Section 34 of the Act, but in computing the limitation period of 3 months for the application under Section 34(1) of the Act, the time during which the applicant was prosecuting the matter bona fide and with due diligence before the wrong court will have to be excluded. Stop.